Loud little ducky coming through, spitting truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose the hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.
Welcome, guys. I hope you liked my intro. I like the song. It was the first time I've tried to do the music with some slides and stuff, but let me know what y'all think. Hopefully we can have more songs. But today we're going to be going over Owens v. Echard. It's going to be the motions for sanctions and the withdrawal, and Woodnick and Gingras going back and forth. So let's jump right in. Motion for judgment on the pleadings and motion to dismiss assigned to the Honorable Julie Matta. He says oral argument is requested. And it says, pursuant to Rule 29, Arizona Family Law Practice, Petitioner Laura Owens, Miss Owens, or Petitioner, moved the court for an order granting judgment on the pleadings with respect to Rule 26 motion for sanctions. The Rule 26 motion filed on January 3rd, 2024 by Respondent Clayton Echard. Mr. Echard, a respondent, in short, the Rule 26 motion claims that Miss Owens lied about every material fact in this case, and he seeks sanctions on the basis. Even if the court found that Miss Owens lied, as Mr. Echard claims, the court cannot award Rule 26 sanctions on the basis due to Mr. Echard's failure to follow the strict requirements of that rule. Okay, so this one he didn't file. This was what he was going to file if Greg Woodnick, Clayton's lawyer, didn't withdraw the motions for sanctions. So this is what he was going to submit, but never did, because Woodnick did withdraw. So let's continue on with what he was going to say. The law is clear. Strict compliance is mandatory, not optional, and where strict compliance is not shown, the inquiry ends. According there is no need for an evidentiary hearing on the trial on the Rule 26 motion. The court may, indeed, must dispose of that issue as a matter of law and dismiss this matter. The court is familiar with the facts, so they will only be briefly summarized. Miss Owens claims she had sex with Mr. Echard in May 2023. She claimed a test showed she was pregnant in June 2023, and after Mr. Echard refused to discuss the situation with her, Miss Owens filed this action on August 1st, 2023. The parties agreed to submit to DNA testing in late September, early October 2023. Those tests were inconclusive. No, they were not. Stop stating this. This is just because you say it doesn't mean it's true. And Miss Owens claims her pregnancy ended with a miscarriage shortly thereafter. Because the paternity issues in this case were moot on December 28, 2023, Miss Owens moved to dismiss the case under Rule 36. On January 3, 2024, just 13 court days after his counsel first appeared, Mr. Echard filed a Rule 26 motion for sanctions. The motion claimed Miss Owens fabricated her pregnancy and thus violated Rule 26B3's requirements, that her claims have evidentiary support. The Rule 26 motion is currently set for an evidentiary hearing on June 10, 2024, but the hearing must be vacated, and the Rule 26 motion denied because Mr. Echard simply did not follow the requirements of the rule. That point forecloses his right to seek Rule 26 sanction, and it precludes this court from granting them. Although there are certainly other hypothetical ways in which parties can seek fees or sanctions, i.e. motion made under ARS 25809 or ARS 12349. Mr. Echard's Rule 26 motion was limited and it was specific. He cited only Rule 26 as the basis for sanctions, not ARS 12-329 or ASR 25-809. Thus, the only question to decide is whether Rule 26 sanctions are available. As this motion shows, these sanctions are not available and cannot be awarded. This is even true if Miss Owens lied about being pregnant. This is so because there is no dispute Mr. Echard failed to follow any of the Rule 26 mandatory technical requirements which this court is required to strictly enforce. That error is the ended discussion. Miss Owens is entitled to judgment in her favor on that basis. No hearing is needed to reach that result because none of the facts requiring this result are contested. The issue is purely a matter of law. Discussion. Rule 29C Standards. Rule 29C provides a party may move for a judgment on pleadings within such time as not to delay trial. When considering this motion, the court must assume all well-pleaded factual allegations in the challenged pleading, AI the Rule 26 motion, are true, and if those facts do not permit relief as a matter of law, judgment should be entered for the adverse party. Giles v. Marcy, 195 Arizona 358, citing Shannon v. Butler Homes Incorporation, one single family resident, real property located, Also see American Fed of State, County, and MUN Employees Council 97 v. Lewis, and a bunch, all those little lovely citings and cases. Here, for the limited purpose of this motion, the court may assume every factual allegation in Mr. Echard's Rule 26 motion is true. The court may assume Miss Owens was never pregnant. The court may assume she filed this action knowing she was not pregnant. The court may assume Miss Owens filed this action purely for non-legitimate reasons. The court may assume Miss Owens is crazy and evil. Under the clearly established standard rules of Rule 26, none of that matters because Mr. Owens failed to comply. Mr. Echard, you mean? Failed to comply, or Mr. Woodnick failed to comply with the strict procedural rules of 26. That error ends the issue. If this court granted sanctions despite that error, the ruling would be erroneous as a matter of law and would be reversed on appeal. Miss Owens is thus entitled to judgment as a matter of law in her favor as the question of Rule 26 sanctions. It's got a footnote, but it just has more citings and stuff we're not going to go over. B. Summary of the Rule 1126 Technical Requirements. As the court will recall, many years ago, the standards for sanctions under Rule 11, before the family law rules of procedure existed, were burdensome and erroneous. Before seeking sanctions, a party was required to 1. Draft a proposed motion for sanctions, 2. Serve the motion on the opposing party, 3. Wait 21 days before the motion could be filed. During that 21 days safe harbor period, the party accused the violation and an absolute right to cure the problem and escape sanctions by correcting or withdrawing the offending pleadings. If they invoked the safe harbor, the motion for sanctions could not be filed and the sanctions could not be granted. Rule Sneller v. City of Bainbridge Island, discussing the former version of Rule 11 and explaining Rule 11 authorizes a court to impose a sanction on any attorney, law firm, or party that brings a claim for improper purpose or without support in law or evidence. Rule 11C, however, provides a 21 safe harbor period. Under this provision, Rule 11 sanctions may not be imposed if the challenged claim is withdrawn within 21 days after service of the sanctions motion. Emphasis added. We don't need your emphasis. Again, you're not writing a script. That burdensome 21 calendar days, now less burdensome, 10 court day waiting period has always been and still is absolutely mandatory without exception. When a party fails to follow the strict requirements of rule, a trial court literally lacks the power to impose Rule 11 sanctions. Westerkamp versus Mueller. More emphasis added. By extension, if a court trial awards Okay, maybe emphasis added is just something you write after a citing. Or he's just emphasizing what other people said. I don't know. Or he's writing a script. Who knows? Let's see. By extension, if the trial court awards sanctions when the safe harbor requirements have not been strictly followed, the result is reversible error, even if the underlying filing is completely frivolous. We must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Holgate v. Baldwin. Emphasis added. The purpose of Rule 11's safe harbor process is easy to understand. People, even the best lawyers, sometimes make mistakes. Whether a violation is intentional, malicious, or just accidental, Rule 11 was structured to encourage lawyers and parties to promptly acknowledge their mistakes by correcting or withdrawing the offending pleading. If that happens, which is obviously a good thing for parties, the court, and the public, the law rewards the responsible party by giving the safe harbor from further punishment. In this way, Rule 11 operates with a carrot and stick design. Even if a party flagrantly violates the rule by intentionally filing a groundless pleading, the rule rewards self-ownership. It does this by granting absolution to all who confess their sins, provided they repent with the rule's safe harbor period. Are we in a church service? Repent. Repent, I tell you. Confess your sins. Yes, Owens, please confess your sins and repent for all the wrongdoings you have done to 5 men and counting. C. Respondent failed to comply with Rule 26 requirements. Respondent failed to provide written notice of his intent to seek sanctions and of Ms. Owens' absolute right to withdraw her petition. In this case, there is no question, none, that Mr. Echard filed his Rule 26 motion on January 3, 2024 without complying with either of the rule's 2 central requirements. First, we know Mr. Echard did not give a written 10-day warning to Ms. Owens because his motion never claims such notice was given. The same issue was also mentioned on page 3 of Ms. Owens' response to Rule 26 motion, as shown here. So let's see what it says. It says, counsel for respondent certified that he met and conferred with petitioner on August 16, 2023, and with petitioner's previous counsel, Alexis Linval, on December 27, 2023. However, respondent's motion did not include evidence demonstrating that the petitioner or the petitioner's previous counsel were provided written notice of a specific conduct alleged to have violated Rule 26b. Written notice is required under Subpart C to B of Rule 26. Without such written notice, petitioner was not afforded time to cure any alleged deficiencies prior to the filing of respondent's motion. Okay, so that was set. And then it says, because Mr. Echard failed to give the required written notice on the point alone, this court lacks authority to even consider, much less award, Rule 26 sanctions. Respondent failed to provide the mandatory 10 court day safe harbor period. A second fatal problem exists. Even if Mr. Echard had given the required written notice, which he did not, he also failed to give Ms. Owens the mandatory safe harbor period, in which she has an absolute right to withdraw her petition and avoid sanctions. The fact precludes any award of Rule 26 sanctions, particularly given that Ms. Owens did, in fact, try to terminate this matter by moving for voluntary dismiss on the case in December 28, 2023. Before Mr. Owens' Rule 26 motion was filed. In this way, Mr. Echard's bizarre actions are very similar to those described in Westerkamp v. Mueller. In Westerkamp, like here, the party who initiated the action, plaintiff sent an offer to the defendant on March 2nd, 2023, offering to dismiss the case. That's a very new case. That case just happened last year that he is referencing. Like here, the party who did not initiate the action, defendant, rejected the plaintiff's offer to dismiss. This is essentially the same thing that happened here, where Ms. Owens moved to voluntarily dismiss the case before Mr. Echard's Rule 26 motion was filed. In Westerkamp, unlike this case, after the defendant rejected plaintiff's offer to voluntarily dismiss the case, but before any sanctions motion was filed, the defendant sent a proper written notice to the plaintiff warning of his intent to seek sanctions. 8 days later, the plaintiff filed a motion to voluntarily dismiss the case, which, like this case, the defendant opposed. Despite the plaintiff's clear attempt to end dispute by offering and then moving to dismiss, the defendant filed a motion asking for Rule 11 sanctions. Given the posture, the district court rightly explained, this bizarre backdrop means the defendant's motion for sanctions must be denied. The court explained defendant's basis for even threatening to seek Rule 11 sanctions based on the allegedly frivolous pleading, let alone formally moving for such sanctions, evaporated on March 2, 2023, when counsel offered to stipulate to a dismissal of the entire case with prejudice. Emphasis added. Because the alleged wrongdoer, plaintiff, offered to withdraw his complaint and dismiss the action before the defendant moved for Rule 11 sanctions, the court held it was powerless to even consider, much less grant sanctions, once plaintiff moved for voluntary dismissal. Defendant was precluded from filing the Rule 11 motion. At 10, emphasis added. The underlying purpose of the safe harbor precludes a movant's ability to move for sanctions given the offending pleading had already been withdrawn via voluntary dismissal. Voluntary dismissal. Blech. In this way, the posture of Westerkamp is not just kinda sorta similar to this case, it is identical. In this case, like in Westerkamp, Ms. Owens sought to voluntarily terminate the case by moving to dismiss on December 28, 2023, several days before Mr. Echard's Rule 26 motion was filed. Exactly as the district court wisely held in Westerkamp, the fact that Ms. Owens sought to withdraw her petition caused the entire basis for Mr. Echard's motion to evaporate, and Mr. Echard was therefore precluded from even filing Rule 26 motion, let alone being awarded sanctions based on it. The authority is clear and it is conclusive. If the court allows this matter to proceed based solely on Mr. Echard's pending Rule 26 motion, it is violating both the letter and the spirit of Rule 26. Mr. Echard did not only ignore the plain requirements of the rule, he has caused Ms. Owens to needlessly incur tens of thousands of dollars in attorney's fees and costs purely for the reasons of spite, rage, and malice. It is not because of rage. It is not out of malice. I don't know about spite. This woman makes people spiteful. But also, if this is true, I mean, it's good that Gingras, I'm saying it correctly while I talk about the douche canoe, because I was corrected, and I thank you for constructive criticism. I will always take it. So even if this is true, and she needlessly incurred tens of thousands of dollars in attorney's fees and costs for reasons of spite rage, not for any of the spite, rage, and malice reasons, just plainly she incurred these fees. I don't think she actually incurred tens of thousands of dollars just because of that sanction. I think that her other attorneys should have caught it if this is really what happened and what went down and this is how this is supposed to be. I mean, it's good that he caught it. Like, that kind of lawyering I can do. That's like good lawyering. You know, if this is accurate and Woodnick didn't do what he was supposed to do or whatever, there was a mistake, it's good that she has somebody coming in and fighting for her with these, because sometimes it goes on a technicality. But that's why you pay good money for good lawyers. Not saying Gingras is a good lawyer. And maybe a good lawyer. He's a shitty person, in my opinion, so far. But, you know, he's on to something here. And this may be the only win that Owens gets in this case. But let's move on to the end of this. As a matter of law, nothing further is necessary for the court to resolve the Rule 26 issue. Ms. Owens is entitled to judgment on the pleadings on that issue, and the failure to grant such request to award any relief to Mr. Echard under Rule 26 is plain reversible error. Accordingly, this court should grant judgment in favor of Ms. Owens pursuant to Rule 26C, and either dismiss this matter as no further issues remain pending, or, at the very least, enter a partial final judgment in favor of Ms. Owens and against Mr. Echard as to Rule 26 motion pursuant to Rule 78B, allowing the entry of a partial final judgment if other claims remain outstanding. Additional comments. To be clear, if the court grants the instant motion, that does not mean Mr. Echard has no further remedies. If he believes he has grounds to do so, he may seek relief under the authorities such as AS 12-349 or ARS 25-809G. He could even send a new, hopefully valid 10-day warning under Rule 26, which would be kind of odd since Ms. Owens would immediately accept the safe harbor and dismiss the case. But Mr. Echard has not brought any such motion, so it is prematurely to speculate about whether and what extent those hypothetical motions would merit the court's consideration, assuming they were filed on some future date. Also, to be clear, even if the court grants the instant motion, that will not resolve Ms. Owens' right to seek fees under the Rule 26 or ARS 1239 or ARS 25-809G. Ms. Owens has previously provided a written 10-day notice of her intent to seek sanctions against Mr. Echard based on his filing a patently groundless and frivolous Rule 26 motion, and assuming Mr. Echard does not avail himself of the safe harbor option, which he could still do, Ms. Owens will proceed with the separate Rule 26 motion once the 10-day window closes. Conclusion. For all the reasons stated above, petitioner moves the court for an order granting judgment as a matter of law as to Mr. Echard's Rule 26 motion dated April 3rd, 2024, and signed by David Greengass, attorney for petitioner Laura Owens. This is that he files this under, certifies this made under a good faith attempt to resolve the issue in this motion, consulting with opposing counsel, and those efforts were not successful. And him signing it, and then him stating that he did send copies to the opposing counsel. And that was the motion that he was going to be filing, but did not. So, we kind of knew all about that. Let's see what this next motion is. Okay, so this next motion is filed. And because this was filed, that is the reason Gingras did not file that one that we just read. Because Woodnick is withdrawing his motion for Rule 26. So, it says, motion to withdraw motion for sanctions pursuant to Rule 26. They really put it out there. They really make these titles like just black and white as to what they are. They don't care if it is a mouthful or not. That is the title. It could be 100 words, but it's going to tell you plain as day what the actual document is, which is nice, so nobody's questioning. But a motion to motion to motion to motion. All right, let's read this. Let's see what Woodnick has to say about Gingras. Here we go. Respondent Clayton Echard moves to withdraw only his motion for sanctions pursuant to Rule 26 dated January 3rd, 2024, based on the following. Although Clayton believes he more than complied with Rule 26 and the court already overruled Laura's objection, it is clear she intends to pursue more toxic litigation predicated on threats as a ruse to avoid this court reaching the heart of this matter, the overwhelming fraud. Yes. Clayton's claims for fees and sanctions exist independently of the Rule 26 motion and have already been set for trial. Clayton would rather avoid the $35,000 sideshow repeatedly threatened by Laura's new counsel and overt efforts to delay adjudication on the facts. Because the Rule 26 motion is not the substantive pleading based for his claims against Laura, there is no reason to participate in pointless litigation over the issue and threats to appeal to further delay justice, notwithstanding Clayton's disagreement with Laura's legal position on Rule 26. Moreover, Laura's threat to seek personal sanctions against Clayton's counsel based on her pro-offered Rule 26 violation, while frivolous, will only draw more attention and animus to the case, subjecting the court to this collateral circus, which is intended only to increase legal fees and prevent resolutions on the merits, would be a waste of judicial and other resources. Accordingly, Clayton hereby moves to withdraw the Rule 26 motion for sanctions filed January 3, 2024. He does not withdraw his counterclaims and other relief afforded and any relief appropriate and available to him under ARS 25-324, 25-415, 25-809, etc. He also, for completeness of record, provides the following. Oh goody. Background and procedural history. This matter is before the court on petitioner Laura Owens' petition to establish, filed August 1st, 2023, and Clayton's amended response to petition to establish paternity, filed December 12th, 2023, relating back to the original filing date of August 21st, 2023. On December 12th, 2023, Clayton moved for leave to amend his response. In the amended response, Clayton cited Rule 26 and provided notice of intent to seek sanctions for statements made in Laura's petition. See amended response, page 56 and 25-26. The court granted leave to amend and accept the amended response on January 25th, 2024. Okay, getting a little background here. On December 28th, more than 10 days after the notice of Clayton's intent to seek Rule 26 sanctions via the motion for leave to amend, Laura moved to dismiss her petition based on her assertion she was no longer pregnant. Her motion to dismiss sought to dismiss the entire action with prejudice. Clayton objected because, inter alia, he had alleged counterclaims seeking an affirmative finding of non-paternity, attorney fees, and sanctions for Laura bringing the action in bad faith for improper purposes, etc. So he's saying, I told her I was going to be filing for Rule 26 sanctions. And more than 10 days after, because she's given that 10-day grace period, safe harbor, she said something. So Winnick is explaining, it seems that we did follow Rule 26 guidelines. Okay. So, on January 25th, the court granted Laura's motion in part by dismissing her petition, but the court did not dismiss the action because Clayton is entitled to resolution of his claim for finding of non-paternity, attorney fees, and sanctions. See minute entries dated January 25th, 2024. While the court will grant the motion to dismiss, the issue of sanctions and attorney's fees remain. The court will set an evidentiary hearing on the issues of sanctions and the attorney fees by a separate minute entry. Prohibiting voluntary dismissal without court approval after an answer is filed and permitting the court to dismiss a petition on such terms and conditions the court deems proper, including the resolution of any claims by the responding party. On January 3rd, 2024, Clayton filed a motion for sanctions pursuant to Rule 26. Hereafter, the motion for sanctions. The motion for sanctions came more than 10 days after the motion for leave to amend, in which Clayton gave written notice of intent to seek Rule 26 sanctions from Laura's complaint. after Laura moved to dismiss her petition. Laura responded to the motion for sanctions on January 23, 2024. In her response, she argued, and her ally, that the motion was deficient because of the lack of notice required by Rule 26C 2B. The court did not expressly rule on the motion for sanctions, but set the matter for trial on attorney's fees and sanctions. Okay, so the judge looked at all this and said, we are going to set it for trial. That's going to be a matter at trial. Okay, judge looked at all of this stuff that has to do with motion for sanctions pursuant to Rule 26. So the judge was not out of the loop. Now, if this stuff didn't happen, could that have to be reversed? Absolutely. But they are saying they complied. This is how they complied. And this is way before Gingrich took over. And so he's explaining that. Now he wants to say, Winnick states, changes of counsel in Rule 26 dispute. At the time she filed her motion to dismiss, Laura was represented by Alexis Linvall. At the time she responded to the motions for sanctions, she was represented by Corey Keith. So she's already gone through 2 lawyers when she got served and then when she responded. Laura brought the same argument related to Rule 26 10-day notice requirement in her response to the motions for sanctions, albeit with less force, and the court still set the case for trial. Ostensibly because even if she is correct and Clayton's Rule 26 motion is denied, there remain other claims that must be resolved before the case concludes. So the judge set it for trial. The judge has heard this argument before. The judge says, I'm not going to rule on that right now. We will take that up at a later date. 7. Her attorney, current attorney, as of the time of this filing, David S. Gingrich, began aggressively asserting various claims, positions, and legal threats in emails to Clayton's counsel after entering appearance on or about March 25th. Yes, he is aggressive. He likes to state a bunch of claims when he doesn't even have all the facts because he's not gone through the whole case. And I don't know what he was doing. I personally think Gingrich is just testing out theories and arguments to see if he could get away with those arguments in court, if people would buy those arguments. And then when people don't and say this is why this argument doesn't work for Owens, he's like, okay, I got to go back to the drawing board. I think that's what he's been doing. And he has the right to do that. He can do that. But he's not. He needs to get himself into the case and know the case before he starts doing all that. Like, know all the facts before you just start throwing theories out there. Moving on, Winnick says, several of these unpleasant emails pertain to the motion for sanctions under Rule 26. Laura asserts that the motion was improperly brought because of the lack of written notice required by Rule 26C 2B, hereafter referenced as the safe harbor notice. This argument is partly articulated beginning on page 14 of her motion for extension of time to respond to respondent's motion to compel, filed on April 1st, 2024, properly denied by the court on April 2nd, 2024. According to her argument, Clayton did not provide sufficient written notice to comply with the rule. Laura interprets Rule 26C 2B as providing the party against whom sanctions are sought a 10-day grace period in which to withdraw or appropriately correct the alleged violation. She interprets withdraw or appropriately correct as giving her an absolute right to withdraw her pleading without consequence or further proceeding. Response to motion to compel at 16 through 17. I don't know that you have the right to do it without consequence. Okay. Further, Laura appears to believe she should have had the right to withdraw her entire petition by virtue of Clayton moving for Rule 26 sanctions without the safe harbor notice, notwithstanding Rule 46. Footnote 1. As articulated more fully below, Clayton believes the motion for leave to amend operates as a sufficient written notice consistent with precedent Laura's counsel cited. Okay, so Clayton believes that even though it's not like a full motion for sanctions, it's mentioned in there, and it's in a motion to leave to amend. He put it in there. He doesn't think that he needs to also give a different motion for that. He did serve her, and he filed a motion, put it in there. She had ample time, and she didn't do it within that ample time, is what I'm seeing that Woodnick is saying. She bases her renewed objection to comply with discovery orders and disclosure obligations on this notion. The only current remaining issue in this case is Mr. Echard's motion for Rule 26 sanctions, which is presently set for an evidentiary hearing on June 10th. He said 2020, but he means 2024. The pending motion to compel seeks evidence which is only and could only be relevant to the issue of sanctions because there are no other pending issues for this court to address. Thus, the only fact of consequence necessary to determine this matter is the question of whether Miss Owens lied about ever being pregnant in the first place. Mr. Echard has no right to his discovery or indeed to any discovery because none of the discovery is relevant to any of the remaining issues of consequence in the case. Emphasis in original. This untenable position, so he's saying that is what Laura thinks. Now when it says this untenable position completely ignores the court's trial-setting order and Clayton's amended response. Clayton has requested relief to which he is entitled to under Title 25, including a finding of non-paternity and attorney fees and costs that are entirely independent from a Rule 26 motion. The applicable statutes including ARS 25-324, attorney's fees and costs for filing in bad faith, filing without ground in fact or law, filing for improper purpose in legal decision-making and parenting time proceedings. 415, sanctions for litigation misconduct related to claims made under 25-403, 403.03, or 43.4. And 809G, attorney's fees for unreasonable in-paternity proceedings. Provide independent remedies that have no grounding in Rule 26. Based on the court's comments, the record at the most recent status conference, and the order setting trial, the court intends to hear those claims for attorney fees and sanctions, notwithstanding the Rule 26 motion. That is why the court did not dismiss the action in its entirety. The court must first resolve Clayton's claims for relief. Number 13. Laura's current counsel communications on this topic are tremendously aggressive, and counsel has taken to Twitter posting pleadings and medical documents contrary to court orders, all of which the court will have to determine propriety and reasonableness under ARS 25-324 come trial. So he's saying, we have a court order not to put this stuff out there to the public. But Gingras is just posting it everywhere and saying, there's not a court order. She can put her stuff out there if she wants to. So at trial, this can be brought up. And Gingras could get in trouble because there is an order. And whether he was counsel at the time that the order went into effect or not, he should be familiar with the case to know that there is an order in place right now that says he cannot do that. These communications, including declaring that Clayton refusing to withdraw the motion would itself be sanctionable under Rule 26, promising to litigate the issue to higher courts at great expense to both parties, threatening to seek personal sanctions against Clayton's attorneys, threatening new bar complaints. Laura have already filed 2 against undersigned counsel and at least 2 to prior attorneys, and so on. In one example, counsel estimates $35,000 in risk if Clayton does not withdraw his motion for sanctions. And he's quoting, "If I was in your position, I would seriously stop and think before telling me to go F myself. You can literally avoid about $35,000 in risk simply by admitting you made a mistake, then doing the right thing. If you decide not to take that safe harbor, it's your decision. But a pretty freaking bad one." Like, there's no reason for that. Like, why do you have to do that? Why can you not be respectful? Like, you don't need to go and cussing at the other attorney. Or cussing at Clayton, or whatever you're doing, Gingras. You need to grow the F up, in my opinion. He says it's not clear whether, moving to the next pages, it's not clear whether the $35,000 is a prediction of legal fees for both parties, a possible attorney's fees award to Laura for acts not yet undertaken, an amount of expected as sanction, etc. But what is clear is that Laura's scorched earth approach to this litigation remains the same as always: to threaten and drive up costs in an attempt to exhaust Clayton's remedies and willingness to defend himself and seek affirmative relief to which he is entitled to under Title 25. The email also concedes, however, that there are other options available to you if you want to seek fees. But you have not made any other motions seeking fees under those authorities. If you think you have factual legal basis to do so, go for it. Emphasis in original. Clayton has already invoked those claims in his amended response, and various other filings and positions in open court. Laura's position self-contradicts in that it simultaneously declares Clayton has no avenue for relief other than Rule 26 and therefore should have no discovery, but also that he can bring claims for relief under other authorities. Now we're going to talk about Clayton's positions. Not in the bedroom, guys. I'm not talking about his positions in the bedroom. His position on this problem. So let's see what he thinks. Interaction between Rule 26, Rule 46, and Title 25. So we're going to get a lesson on these. As a threshold matter, the policy implications of Laura's petition that Rule 26 10-day notice and safe harbor language granted an absolute right to withdraw a petition and defeat the responding party's entire case are both severe and obvious. A party who has already filed a response and brought counterclaims for relief would never invoke Rule 26. If doing so would give the petitioner carte blanche to withdraw their pleadings with no limitations. Number 17, Rule 46 expressly prohibits voluntary dismissal of a petition after a responsive pleading is filed or evidence is taken, particularly when the responding party alleges affirmative claims for relief, as Clayton did here. The suggestion that the 26 10-day rule notice supersedes Rule 46 is illogical and would deter parties from seeking Rule 26 relief at all, especially in cases of the most egregious conduct Rule 26 is meant to prevent. Rule 46 locks in the party's petition once a response is filed and guarantees the respondent the opportunity to present their claims for relief, even if the petitioner changes their mind and wants to opt out of the litigation. So Rule 46 says if you can file your thing. So Laura can sit here and file and say, oh, Clayton's the father of my babies and da-da-da-da-da, and I'm pregnant. But once Clayton comes back and responds and says, no, I'm not, we just had oral, you're a liar, 46 will not allow Owens to say, you know what, never mind, I'm not pregnant anymore. Because there's already been a motion or a filing and claims, and the responding party has already responded. So we have to see this litigation through, according to Rule 46. Now, if there is no response, they can withdraw, but it has to be before that first response, which was a long time ago. 18. Laura is correct that failure to comply with Rule 26 results in relief for that motion being denied. But to suggest that failure to comply with Rule 26 results in effective waiver of all claims in the litigation would interpret a procedural provision of Rule 1 in a way that swallows this entirety of another. A harmonious reading of Rule 26 and 46 is simple. Failure to comply with Rule 26 results in not receiving Rule 26 sanctions for that motion. It does not prohibit a subsequent Rule 26 filing with a new 10-day notice, nor does it afford a party who violated Rule 26 an opportunity to dismiss the entire litigation during the 10-day notice period. Laura's interpretation would render Rule 26 practically useless because no party with valid claims for relief would risk waiving their right to resolution of those claims, a right guaranteed by Rule 46. Rule 26 procedural requirements do not supersede independent claims for relief given by law, including claims under ARS 25-324, 415, and 809. Nothing in the Rule 26 indicates, nor could it, given the supremacy of statutes over procedural rules, that a party waives their right to bring their sanctions or statutory claims by invoking Rule 26. This would create an absurd result and exalt form over function in the most problematic way. Okay, we're still continuing. This video is not going to be as exciting as some of the other ones, but it's a part of the case and it's a part of the fighting, and we get to learn something that we maybe didn't know about. So I hope you're sticking with me. The difference between Arizona federal laws and procedures and stuff. Laura's petition relies on case law interpreting Rule 11 of both the Arizona and the Federal Rules of Civil Procedure, although Rule 26 is based on Rule 11, and case law interpreting Rule 11 is instructive. It is not dispositive. Of relevance to this case, Rule 26 exists in the context of remedial statutes present in Title 25 that are not available in other civil proceedings at either the state or the federal levels. Laura herself believes correctly that attorney's fees and sanctions are available under ARS 25-809G, independent of Rule 26. Clayton has already identified the statute and at least two others in Title 25 that simply require the court to consider reasonableness of positions, bad faith, improper purpose, etc., as part of this action. None of these statutes apply to general civil matters in state or federal courts. Put another way, Rule 11 precedent exists in a completely different legal context where awards of attorney's fees are more limited, such as fees provisions in contracts under ARS 12-341-1, damages not to exceed over $5,000 for frivolous claims, delay, or discovery abuses under ARS 12-349, liability for excessive cost under 28 U.S.C. 1927, relevant to the Holgate decision discussed below. So, Gingras cited Holgate in what he was going to submit. So now they're going to talk about Holgate, because he was responding to this. Clayton denies that these cases, or indeed any Rule 11 case at the state or federal level, categorically disposes of an analogous, why can I pronounce that word, issues under Rule 26. That said, to the extent they provide persuasive authority, he will address the primary cases Laura cites on their merits. In the Holgate matter, Laura's counsel cites and argues in support of her position the trial court could not award sanctions under 28 U.S.C. because it did not find bad faith required under the statute. According to the movant's alternative claim for sanctions under the court's statutory authority was unavailing, and they brought no substantial legal basis to request those sanctions except under the flawed Rule 11 motion, Holgate v. Baldwin. It should be noted, the Holgate decision expressly declines to award sanctions for Rule 11 notice error for opposing a plaintiff's motion for voluntary dismissal, stating the appropriate remedies is to denial the request for Rule 11 sanctions, not award counter sanctions, as Laura threatens to request. Holgate at 680. Clayton denies his Rule 26 motion for sanctions lacked proper notice, but even if it did, Laura's threats are contrary to the very precedent on which she relies to make them. So stop making your threats, Gingras and Owens. Your threats are not happening. They're going nowhere here. So shut your trap. Of relevance here, there was no alternative basis for the claim for attorney's fees and sanctions under applicable federal law in Holgate. So the court could not sanction on its own motion without finding bad faith. Rule 11 was an exclusive remedy in the context, but Rule 26 is not the exclusive remedy for the basis for Clayton's request for fees and sanctions under Title 25 of Arizona Revised Statutes. Notably, under Rule 26, the court can move for sanction on its own motion, which is likely appropriate given the exorbitant amount of fraud perpetuated by Laura in this and the collateral matters. So the court can move for sanctions. The judge can make sanctions happen. And he thinks that that would be really appropriate given the huge amount of fraud and lies, deception, perjury, falsifying documents that Owens has done in this case. The judge can say, you know what? No. You're not going to walk away with this as a just, you know what, you shouldn't have done this little slap on the wrist. We are going to we're going to make you pay sanctions because you don't need to be pulling this BS anymore. Like, it's not going to happen. Similarly, Laura relies on Gallagher v. Serrano law offices, a trial court decision summarizing applicable Rule 11 precedent. Although Gallagher is not precedential, Clayton finds the same problem with the analysis in that case. The party seeking sanctions cited ARS 12349 and 250 as an alternative basis, but did not prove the required factors, including bad faith, subjective intent, financial positions of the parties, etc. Critically, the court considered awarding fees and sanctions under authority unrelated to Rule 11. Notwithstanding the motivant's failure to comply with Rule 11's 10-day notice requirement, this case does not stand for proposition that Rule 11 is the exclusive mechanism for seeking fees and sanctions. The court declined to award the statutory remedies, but the fact it considered them belies Laura's position that the 10-day notice in Rule 26 gives her an absolute right to withdraw her petition and thereby dismiss all of Clayton's claims. Title 25 is far more remedial and contains numerous mechanisms for fees and sanctions that do not exist in the Rule 11 context, warranting a much broader interpretation of Rule 26 and the availability of other remedies. Laura also cites Barber v. Miller, another Ninth Circuit case involving an appeal sanctions without the 10-day notice. The primary issue in Barber is whether a party receives sufficient notice and opportunity to withdraw or correct their filings when the movement moved for sanctions after the complaint had already been dismissed. The movement also failed to serve a copy of the motion before filing, under a prior vision of the Rule 11 that required service of a motion for sanctions and a 21-day waiting period before filing. The Barber Court reversed the sanctions because a party cannot wait until after summary judgment to move for sanctions under Rule 11. So you would have to move for this sanctions rule before a judgment was rendered by the judge. So that's why this case doesn't matter in this case, because we're not at, he has moved for these sanctions before there's been a judgment. So that's why this case that Gingras cited has nothing to do with this one. In Barbara, the court also devoted significant attention to the difference between Rule 11 sanctions imposed by a motion of party and imposed sua sponte by the court. Barbara states that sanctions imposed upon motion of a party and those imposed by show cause order on the court's initiative are substantially and procedurally different. Critically, the version of Rule 11 the Barber Court interpreted only allowed an order for payment of attorney's fees directly to the movement if imposed on motion, not on the court's own initiative. The Barber Court could not interpret the sanctions award as the equivalent of the election by the court to impose sanctions on its own motion because the rule did not substantially allow the form of award except by motion of a party under the vision of the Rule 11 then existing. Contrast with Rule 26 allows the court, on motion or on its own, to impose an appropriate sanction, which may include an order to pay the party or parties the amount of reasonable expenses incurred because of the filing of the document included reasonable attorney fees. Emphasis added. Okay, so I'm guessing he's not writing a script because Woodnick just added emphasis on that. Oh well, I was really having fun joking about that. But I will stop. Number 28. Rule 26 does not distinguish party motions and sua sponte sanctions in the same way Rule 11 did when that case was decided in 1998. The Arizona family law practices did not even exist at the time, and it allows the same form of sanctions regardless of whether the sanctions are upon motion of a party or the court's own initiative. Barber tells nothing meaningful about Rule 26 in this context. Sufficiency of Clayton's notice and authority to sanction. Clayton asserts the notice he gave in his motion for leave to amend and the amended response complied with Rule 26C2B. The amended response specifically identifies the pleading and conduct that he believes violates Rule 26B. Clayton filed his motion for sanctions separately several weeks later, i.e. long past the 10-day safe harbor period Laura claims she did not receive. In Holgate, one of the parties, the Newells, has their sanctions award upheld on appeal despite not sending separate notice of the intention to seek Rule 11 sanctions. Instead, they filed a motion to join in the sanctioned motion of another party and served their whatever. So like I was saying, he gave her notice. He didn't think that he needed to send a separate notice. He already included it. He said he did end up doing that, but he didn't do it. And in Holgate, apparently they did the same thing. They put it in a motion, but they did not do a separate motion saying it. Because You got the motion and you got the thing saying that they were going to be seeking sanctions. So you were given notice that this was going to be happening. Just because it didn't come in a separate notice doesn't mean that it didn't happen. Joiner motion the same day they filed it. The Joiner motion was the first notice the opposition had of their intent to seek sanctions against him. They filed a second motion requesting sanctions a month later. The Holgate Court found the safe harbor period commenced when the Newells filed their initial Joiner motion, and the second motion for sanctions supported an award of sanctions. In summary, because Levinson had prior notice of the frivolousness of the complaint from the Baldwin motion and notice of the second forthcoming motion for sanctions, we conclude the district court did not abuse its discretion by awarding sanctions to the Newell defendants. So, Woodnick says, he did do this. So, all that Gingras said about him not giving Owens notice is not true. And that is supported by the Holgate case. 31. Nothing in Rule 26 suggests the safe harbor notice is not satisfied by filing and serving an earlier motion that provides an opposition with notice of the conduct alleged to violate the rule. Rule 26 does not reference a form or provide specific language that must be included in the notice, like many other rules and statutes do. Rather, it requires the party to be sanctioned has actual notice of the allegedly offending conduct and an opportunity to withdraw or correcting the filing. In fact, Laura did try to withdraw her petition after Clayton's motion for leave to amend, and the court declined to award the complete dismissal. She now asserts she had an absolute right to receive. He's saying, recall Holgate, where the court denied it. The sanctioned party for opposing a plaintiff's voluntary motion to dismiss, just as Clayton did here. So Holgate, as far as the sanction stuff go and voluntary dismissal, Holgate really supports Clayton's position on this. Laura's present-day assertion that she would have withdrawn her petition upon receiving Rule 26 notice is not persuasive of anything because her actions would not have changed whatsoever. She was not prejudiced. She asserts that she did not receive proper notice and therefore had no opportunity to withdraw her petition, but the fact she changed position in response to the motion for leave to amend by moving to dismiss her petition, I'll bet after the 10-day window before Clayton could file the motions for sanctions. Laura was not prejudiced because she would have not done anything differently had she received a separate notice, in whatever form she believed would have been proper. She had actual written notice, changed position in response to the notice in an attempt to withdraw her petition, and the court denied her that relief because it must resolve Clayton's claims before disposing of the action. Yeah. Prove you were pregnant. Prove he was the father. You need to prove these things before we get to any of that other stuff. Even if the court finds Clayton's notice insufficient, the remedy is to deny the request for sanctions based on his Rule 26 motion. Holgate, Rule 26 sanctions for improper procedure, and seeking Rule 26 sanctions would create an illogical cascade of motions and counter motions akin to two mirrors facing one another. Nothing in Rule 26 would prevent Clayton issuing a notice and filing for sanctions after the new 10-day safe harbor period. The court issuing sanctions on its own motion, which the rule expressly allows. 3. Laura filing a motion for sanctions if she believes one is appropriate after following the procedures. Or 4. The court awarding attorney's fees and costs and other appropriate awards under the numerous statutes allowing or requiring such relief with no relationship to Rule 26. Indeed, the court must resolve the statutory claims for relief, notwithstanding whether Clayton or Laura ever filed anything pursuant to Rule 26, and the denial of Rule 26 sanctions has no impact on the substantive claims the parties have brought. So who cares about the sanctions? Because whether those are filed or not filed or whatever, they have no bearing on this court case as far as the heart of this case. Withdrawal of Rule 26 motion. Ultimately, although Clayton believes he complied with Rule 26 and that the court already overruled Laura's objection, it is clear she intends to continue her established pattern of threatening her way through the litigation, refusing to comply with her discovery obligations, and seeking to avoid merits of the case through any means necessary. Clayton claims for fees and sanctions exist independently of Rule 26 motion and have already been set for trial. With or without Rule 26 motion, those claims require resolution, as the court already found when it preserved them while dismissing Laura's petition. Clayton would rather avoid $35,000 sideshow Laura intends to use to distract from the merits of the claims against her. Because the Rule 26 motion not substantial pleading basis for his claims against Laura, there is no reason to participate in the pointless litigation of the issue, notwithstanding Clayton's disagreement with Laura's positions on Rule 26. So they don't agree with Owens and Gingras and their position. Subjecting the court to collateral chaos, which is intended only to increase legal fees and prevent resolution on the merits, would be a waste of judicial resources. Moreover, Laura's threat to seek personal sanctions against Clayton's counsel based on her proffered Rule 26 violation, while considered frivolous, will only draw more attention and animus to this case. Withholding the Rule 26 motion will not affect the court's duty to resolve claims Clayton properly brought under Title 25. It will, however, prevent the wholesale wasting of judicial resources and attorneys' fees on this meaningless procedural issue. Accordingly, he moves to withdraw the Rule 26 motion for sanctions filed on January 3, 2024. He does not withdraw his counterclaims for the finding of non-paternity, attorney's fees, costs, sanctions, and any other relief appropriate and available to him under ARS 25-324, 25-415, and 25-809, etc. Respectfully submits to the court, and they gave a copy to Gingras and the judge, and Greg Woodnick signed it. So there we have that. Greg says, not so fast, Gingras. Nice try, but we're not just bowing down to your threats and saying, oh, you're right, let me tuck my tail. No. He's going to call you out. He's going to show you in court, because he doesn't need to go act like an asshat in the public, in the media, to get his point across. He just puts it in the court filings. So well. This is the verification that Clayton Echard declares under penalty of perjury, that he's read the foregoing motion and the contents thereof are true and correct according to the best of his knowledge, and then he signed it himself on the 3rd. All right, now we get to Gingras's response to what Woodnick just said. On April 3rd, 2024, respondent Clayton Echard, Mr. Echard, or respondent, filed a lengthy 26-page motion seeking to withdraw an earlier Rule 26 sanction motion he filed in this case on January 3rd, 2024. To help expedite matters, petitioner Laura Owens, Ms. Owens, offers 2 brief remarks. First, technically the motion to withdraw could be denied because it does not comply with Rule 9c. The motion does not contain a Rule 9c certificate, which is not surprising because respondent's counsel did not meet and confer with petitioner's counsel before the motion was filed. The issue notwithstanding, in the interest of efficiency, Ms. Owens does not oppose Mr. Echard's motion to withdraw the prior sanctions motion, and she agrees the court may consider that motion essentially moot. Second, the motion to withdraw, which could have been a simple 1-page, 1-line stipulation, isn't really what it appears to be. The motion isn't really about withdrawing anything. If it was, Respondent's counsel would have met and conferred, learned that petitioner would stipulate to the relief requested, and no motion was necessary. Respondent's motion is really not a motion at all. It is rhetorical manifesto, which serves 2, maybe 3 main functions. For one, it hurled pejoratives at both petitioner and undersigned counsel. Okay, that's fine. We assume that this was done as a response to the longer motion petitioner filed on Monday, which the court denied on Tuesday. Okay, fair. The pseudo-motion also seems preemptively argues certain legal points regarding the availability and propriety of sanctions and fees. Why do this in a motion that asks to withdraw a request for sanctions? The answer is obvious. Mr. Echard wants to plant seeds in the court's mind, hoping to harvest them for later. But you also said those in what you were going to file, so he had the right to mention them. He didn't just bring them up just because. He mentioned them because you mentioned them. But go on with yourself. As anyone who knows the undersigned will attest, he is sometimes often long-winded, and usually is happy to engage in lively and wordy debates over matters of law. But now is not the time or place for that. This court is busy and has other matters to attend. Mom, he's writing long motions. Judge, tell him to stop writing long motions. It's wasting court's time. I wouldn't want to waste the court's time, Judge, you know. I like to kiss butt. As such, while the undersigned can and surely will provide the court with a helpful and thorough explanation of the correct legal standard for sanctions, fees, and other related issues, which will basically destroy the remarks of Mr. Echard's pseudo-motion, this will have to wait for the proper time and place. For now, we should all focus on more pressing concerns. I am the brown noser. I am the brown noser. I am not going to waste your time with long motions, Judge. But yet you do. Yet you do. And then here is the minute entry. The court has received and considered petitioner's motion for extension of time to respond to respondent's motion to compel filed on April 1st, 2024. It is ordered denying the motion. All parties representing themselves must keep the courts updated with address changes. A form may be downloaded. So Gingras hopped on the case. He wanted more time than was originally given to respond. And the judge said, no, you need to respond by the date that's been set. And because she's probably like, this case has gone on way too long for what it is. Paternity matters are not supposed to last this long. It's supposed to be quick and easy. You're the father, you're not the father. You're pregnant, you're not pregnant. But Owens has made this last forever. So judge says no extension of time. Get it done now. If you made it this far, thank you. I know that wasn't the greatest thing, but we got to know the whole story, right? If we're going to make decisions, and we need to see the whole picture. And if Gingras was right, then he was right. If Woodnick is right, he was right. But we need to see both sides, not only one side, to be fair. But that is where we're going to end this video today. Our quote of the day: a mistake is only an error. It becomes a mistake when you fail to correct it. John Lennon. So if you mess up, you can correct it, you can own it, you can apologize, you can do all of that. But if you make a mistake, it is not a mistake once you do not correct it and you continue to mess up and mess up and mess up on the same thing. That's not a mistake. That's not an oopsie daisy. Mistakes we can own. So a mistake is not what Owens has done here, because she has done this numerous times. But it is okay to make mistakes. If Woodnick made a mistake, he can correct it and move on. Makes it only an error. And I think Woodnick would be that type of person. Whereas Gingras doesn't own any mistakes at all. He doesn't seem to correct his behavior either, like his client. Anyways, just remember that we're all human. We will be going over some other filings. We've got the motion to compel lunch, and some other stuff coming up. As soon as we get through this part, we will be starting the Greg Gillespie case. I'm excited for that. So hit like, subscribe, turn that notification bell on, and I will see you next time. Bye.